I know you have an interest in everything I just presented, so I'm going to do something I don't usually do. Where would you like to begin?
Well, I suppose I could begin with the very sound opinion by the judge in New Mexico who enforced the 14th Amendment in an opinion that said it really didn't matter whether this county commissioner was convicted of insurrection. He was actually convicted only of entering a federal building without permission. But this judge said that he's bound by the rule of law. And the law under the 14th Amendment is that if you take an oath, and every official has to take an oath to the U.S. Constitution, and are then involved in what amounts to an insurrection, whether you've been convicted under the Federal Insurrection Act or not, you can't serve. And his opinion is filled with references to other insurrectionists. He passingly refers to Donald Trump, but he doesn't distinguish Trump just because he's the former president from a mere county commissioner. He knows that all are equal before the law. And I think that Judge Cannon could take a lesson from that, because she quite explicitly says, in her opinion, doing for Donald Trump something that no judge has ever done in the history of the country, and that is putting a stop to the prosecution because there are a few personal items along with things like national security secrets. She says, well, it's because he's Donald Trump. He's special. He's privileged. She says the quiet part out loud. We don't know whether they found her as the judge they could count on, although it's suspicious. We do know from her own opinion, which everyone who is an expert in the law has trashed, everybody from Bill Barr on the right to people on the left. It's not really a legal opinion, but it's an opinion that she says he deserves, because guess what? His feelings might be hurt. His reputation would be smirched just by the very fact that the government is searching through his stuff. Well, a lot of people have reputations. As I think you said yesterday, one of them might not be Donald Trump, but the idea that we should care more about his reputation than that of anybody else because he was the president is very much like his idea that he is still the president. We get emails, people like me get emails every day from President Donald Trump. And he says, you're one of my best supporters. I don't know where he got that idea, but he's still talking about himself as though he's president. So I don't know where else you'd like me to go with this, Lawrence, but I think we have a picture of lawlessness by courts that are faithful to Trump and not the Constitution. And then we have some state courts still who believe in the law.
Professor Tribe, I'm so glad to know that the Trump fundraising email list is so badly managed that both of us are on it. But now let's go to this dilemma that the Justice Department faces, have to make a decision by Friday to appeal this order that seems completely indefensible. But they'd be appealing it to a circuit court of appeals that is dominated by Trump judges. And I mean, you have been an appeals counsel at the highest possible level, the United States Supreme Court. You know this kind of calculation. Do we bring this appeal if it creates the possibility of actually creating truly bad law and really locking it in? If this judge's opinion is affirmed by a Trump-dominated Circuit Court of Appeals and then by a Trump-dominated Supreme Court, what should the Justice Department do? Bill Barr says they should appeal.
Well, I'm not always sure that Bill Barr has the best interests of the federal Justice Department under Merrick Garland at stake. I don't think they have to take an extreme position either way. They are supposed to name some possible special masters by Friday. They could suggest that the one part of her opinion that cannot stand and that she has to suspend is the part that puts a freeze on the investigation. She claims to believe that you can stop the criminal investigation based on the material that was seized, including the top secret material, but you can continue protecting the national defense through the ODNI, the Office of Defense Intelligence, that you can do both at the same time. But actually, as I think Andrew Weissman and others who have been in this business know, it's impossible. It's like, it's unwinding a hopeless pretzel, because it's the same people who are doing the investigation. If you want to figure out who might have seen the top secret information about another country's nuclear military capacity, you've got to know who was in with those boxes, who went through his desk, whose fingerprints are on these things, who might have been there. That's simultaneously a criminal investigation and defense intelligence assessment. So if she refuses to disentangle that knot, then they have a basis for an emergency appeal on that limited issue. And I think even a very right-wing court might recognize that the national defense is a bit beyond political party. She said herself in a footnote that she would want to go ahead and appoint this special master to find the attorney-client privilege material, even if her restraining order, which, by the way, the former president didn't even ask for. He only asked for an injunction until a special master is appointed, but she went further. She gave him more than what he asked for. So she's made it clear that if that part is suspended, she's almost inviting them to suspend it, then she will go ahead with her special master, which is crazy and makes no sense, but at least wouldn't necessarily destroy the national defense, and the investigation could go on. So I think the Justice Department can craft a solution that doesn't involve just tossing their fate into the pit of lions, in which 6 of the 11 judges of the 11th Circuit are Trump appointees. And by the way, the circuit justice for that circuit is, wait for it, Clarence Thomas. That's not a good look. They don't necessarily, in other words, have to take Bill Barr's advice, but it's a close question.